Hearing in the appeal, Sara and Hossein Asset Holdings Limited against Blacks Outdoor Retail Ltd.
Yes.
I feel the appellant in this matter with my learned friends Mario Bennett and Hossein Mahani, and my learned friend Richard Fowler appears for Respondent. My Lords, in a nutshell, this appeal relates to the proper construction of a certification provision in a lease relating to service charges, and the question whether that certification enables a landlord, aside from manifest or mathematical errors or fraud, to determine between landlord and tenant conclusively that an item of expenditure which in truth is not payable by the tenant under the terms of the lease is nevertheless payable by the tenant purely by reason of the landlord's certification. It is a point of construction, and reading the appellant's and respondent's cases, unsurprisingly, there is no disagreement in one sense about the principles. The question is, how do they apply to the exercise of construing the lease, and whether the Court of Appeal, in coming to the conclusion it did, erred in that respect. And this court is obviously very well aware of the fundamental principles of contractual construction, and indeed Lord Hodge particularly so, since I'm about to just highlight a few points in judgments of your Lordship. Really, because here we say, in the iterative process that is called for, when dealing with a lease, dealing in particular with a service charge regime of the detail in this lease, which is not uncommon, then what I will call the documentary context and what might otherwise be called the internal context of the contract is key, and it is delving into that, or failing to delve into that, that is at the root of the Court of Appeal's error. Just quickly before I take your Lordships to the provision themselves, just to highlight the point I've made and the importance of what I've called the documentary context. The court will be very familiar with the decision in Arnold and Britton and Wood and Capital. But if I can take you briefly to Arnold and Britton, it starts at page 700 in the bundle.
We will not need an extensive citation of authority.
Then I will simply read, if I might, the phrasing that I wish to hone in on, if that is satisfactory. It's in paragraph 70 of my Lord Hodge's judgment. The background to the sorry,
electronic page.
You do need the page.
We do need the page, yes.
719. I do apologise.
Thank you.
Having referred to Chartbrook, the background to the deal and the internal context of the contract showed that there was a linguistic mistake in the definition which the court was able to remove by the means of construction. Again, at paragraph 71, that internal context of the contract providing the answer. Now, I'm not suggesting in this case that this is a mistake in the language in the same way as Chartbrook, but it's the importance in the iterative process of taking the language of the provision one is concerned with, and particularly where there is more than one possible meaning that could be described as natural or ordinary. The context involving the internal context of the contract or the documentary context, as well as potentially the commercial context. And that again is highlighted in the very well-known page 903 of the bundle, paragraph 12 of Wood and Capita. Again, and I do apologise for this, Lord Hodge, clearly making your lordship a good person to be dealing with this matter. The unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial context.
Sorry, I misheard your electronic page number.
Sorry, it's 903.
Thank you.
The bottom of the page, paragraph 12.
Got it. That's...
And then carrying on towards the bottom, to my mind, once one has read the language in dispute and the relevant parts of the contract that provide it does not matter whether the more detailed analysis commences with the factual background or the implications of the construction or the close analysis of the relevant language, as long as the court balances the indications given by each. Can I also at the outset make clear, my lords, that we, and I hope it's clear from our appellant's case, we are not saying that it is impossible as a matter of principle, as a matter of law, for a landlord and tenant to agree a certification provision that would have the all-encompassing effect that the respondent argues for in this matter. We just say, in order to do that, it would have to be very clear about the scope of the certification and the scope of the certification's conclusivity, and that is not this case. We are also not, despite the suggestion to the contrary, my lords, trying to avoid a bad bargain. Rather, the opposite. The appellant's case is that we seek to have the whole bargain, the bargain that was represented by the terms of the service charge regime, and not a bargain skewed by an interpretation of one provision in that that does not take proper account of the rest of that regime and does not look carefully at the language in that certification provision and how it slots in to the rest of that.
You're saying we need to study all the paragraphs of all
Indeed.
the relevant paragraphs of Schedule 6, in particular 8 and 13.
Yes.
Yeah.
But also 1 and 2 that feed into 3.
Yes, of course.
And then 9 and 10, which deal with the excluded costs. So I will take you to those now. It seems a sensible point to take it. The lease starts at page 365 in the bundle. Just very quickly, on 371, we have about almost 3/4 of the way down the page, clause 213D, which is the obligation to pay on the tenant's part. And it is paying during the term service charge calculated and payable at times and in accordance with Schedule 6. So just to highlight, it's the whole of Schedule 6 that is referred to. Your Lordships will no doubt have picked up there's a Part 1 and a Part 2 to Schedule 6. But also what one is taking from Schedule 6 is the calculation of what elsewhere is called the further rent, the provisions as to timings and the sequence in which payments are made, and in accordance with which we say is the subject matter, the substance of the service charge to which the calculation is applied. Briefly at 374, we have clause 5.4, which is the landlord's obligation to maintain and keep in good and substantial repair and condition the structure and exterior of the demised premises, and to provide those services referred to in Part 2 of Schedule 6. So that clearly contemplates that the landlord's obligations in terms of work may very well, depending on what's required year to year, extend beyond the services in Part 2. Can I then take your Lordships to the all-important Schedule 6, which starts at page 376.
I've been working on page 566. Can I take it there just the same?
You can, my lord.
Thank you.
If I can just highlight, but we'll look at the detail later, that over the page at paragraphs 9 and 10, we have 9 provision for excluding the excluded costs and 10 the definition of them. So they are in Part 1. I can then go to the beginning, paragraph 1 of Schedule 6. It provides for the landlord to calculate as soon as practicable after the 31st of December the total reasonable proper cost to the landlord during the calendar year that's ended of the services and expenses specified in Part 2 of this schedule, excluding costs and expenses met, not to be met, or that might be met by the insurers under policies of insurance affected by the landlord hereinbefore mentioned. So the calculation of what fits in that expression, the total reasonable proper cost to the landlord, the subject matter is the Part 2, services and expenses, with some potential deduction if insurance monies have already been recovered.
Can I just check one thing? Is the service charge element part of the rent for the anti-set-off provision?
Yes.
Yep. Okay.
I think that was a matter of some debate in front of the master, and it was.
But it's been a matter of agreement thereafter, I think.
Yes.
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 Yep, I just wanted to check. Thank you.
So moving
Is there
on.
anything in clause 5.4 that goes further than in what's in Part 2 of the Schedule 6? So that it's noteworthy that paragraph 1 doesn't refer to the landlord's costs of complying with clause 5.4.
No. So it is confined, it's not as extensive as the works. So, my lord, I
Well, no, but I'm looking, for example, at the language of Part 2A, Services 1, maintaining, repairing, cleansing, decorating, etc. I mean, is there anything in clause 5.4 that's not also there? In one, I mean, 1 and 2 seem to me to be the maintaining, repairing obligations. Although you get repaired and decorated again in 4.3 in relation to the common parts.
It's maintaining, repairing, cleansing and decorating the structure and all external parts of the building.
Oh, you made the point that 5.4 appears to be a repairing obligation and to provide the services referred to in Part 2.
I did.
But I'm wondering whether, in fact, when you get to Part 2, it isn't comprehensive.
Well,
If it
my
isn't,
lord,
I'm not quite
arguably
sure
not.
what provision there is for the landlord to charge it to the tenant at all.
Arguably not. The sections in Woodfall that have all the different possible language used in repairing covenants flash before my eyes. And here we have to keep in good and substantial repair, which is not language that is reflected. And certainly there can be arguments about whether it's much easier to argue to keep in good and substantial repair would include putting into repair if it wasn't at the start of the lease, whereas simply maintaining and repairing may well not.
I mean, there's nothing in 5.4, is there, about recovery of the costs from the tenant?
No.
So that insofar as 5.4
is wider,
poses an obligation that's wider than Part 2 of Schedule 6, it's not one that the landlord can
would
charge.
feed through. No.
May I ask, has this been explored in front of the courts below? This question of whether 5.4 extends beyond the services in Part 2?
No.
But it's,
I'm just highlighting that one needs to look carefully at the language to see what is and isn't in, because when we come to look at the certification provision, we, in our submission, have to be very conscious what is being certified compared to what the lease actually provides for.
So you say there is stuff in 5.4.
There is the
So
potential.
under this lease, the landlord
It's
is
not my best point.
undertaking some repairing obligations which he can't charge the tenants.
Indeed, there is the potential for that, my lord. The more important one, when you come to it, is the excluded costs. But certainly the potential there. My lords, if I can then move us on to paragraph 2. Further rent payable by the tenant shall be a sum equivalent to the fair and reasonable proportion of such total cost of the services and expenses specified in Part 2 of this schedule, and in the event of the term commencing, etc., etc. Apportionment. So such total costs and specific reference to Part 2 give us the scope of what the fair and reasonable proportion is to apply to, and tallies, as the word such would suggest, with paragraph 1. Paragraph 3 goes on, the landlord shall on each occasion furnish. We would say that is referencing the paragraph 1 as soon as practicable after the 31st of December. As soon as practicable after such, total cost and sum payable by the tenant shall have been ascertained. A certificate as to the amount of the total cost and the sum payable by the tenant, and in the absence of manifest and mathematical error or fraud, such certificate shall be conclusive. So it's using again the language of total cost, such total cost, and the only total cost that has been featuring is the total cost of the services and expenses specified in Part 1.
In Part 2.
Sorry, Part 2, I do apologise.
So you would accept that a certificate wouldn't be it would be an erroneous certificate if it simply included what the landlord has spent without regard to what he was obliged to spend.
Indeed. But whether it was erroneous in a way that would allow what have been referred to as the reserved or the permitted defences to operate and save it would depend on whether it was manifest, mathematical, or fraud.
And the certificate could just be a single figure.
It could. Because it's asking for the total cost. So one would anticipate. Obviously, a landlord may well provide an awful lot more, but that the actual certificate bites on two figures, total cost and sum payable. And we say the reading of this provision has two potential effects in terms of the certification. That identified by Master Bartlett, and as she then was Deputy Kelly Bacon sitting as a Deputy High Court Judge, which is that it certifies the amount of the total cost and the sum payable.
So there'll be,
So both the amount.
have a certificate just saying, I hereby certify Tommy, and then some B, and then a signature.
Yes. So it's certifying both amounts.
Yes.
Whereas the Court of Appeal concluded, and I'll take you in the judgments later, that the word amount only applied to the total cost and didn't apply to the sum payable, and we can see that in, as he then was Lord Justice David
But
Richards.
the sum is also an amount, isn't it?
Yes,
I mean, is there
and that's what we say. All it is doing, as Master Bartlett put it, is the sort of accounting exercise of certifying the quantum, the amount, the figure,
Just
not the underlying liability.
before you move on, in paragraph 2, it talks about that what's payable by the tenant is a fair and reasonable proportion of the total cost. Although when you get to paragraph 6, it's actually based entirely on a comparison of net internal areas.
Yes, prorated by.
And the only other sense in which there may be any apportionment in 2 itself is if he's only there for part of the period.
Indeed.
So does fair and reasonable, it doesn't introduce any wriggle room, does it? It's strictly based upon areas with an adjustment if he's only there for part of the year.
It doesn't create a second test. What we see when we read 2 on its own, we think that there is a judgment call to be made in the broadest sense of fair and reasonable. But actually, when we get down to 6, we see that in effect, although it's not put in quite this way, the parties have in the lease provided what is fair and reasonable.
Yeah.
And there is a surveying judgment call, but not the general justice, what's fair and reasonable call. And what's really important as we've gone there at this stage is that when one looks, and again I'll take you in due course, at the Court of Appeal's judgment, even the Court of Appeal accepted that the certification in 3 was subject to 6. And of course, at the start, first certificate, it's not until you get the certificate that you have the landlord's proportion. And so it is inevitable that any expert determination in relation to the proportion that arises under paragraph 6 will come after the certificate.
Why could not the tenant and the landlord sort out any dispute about the area apportionment before the first service charge certificate comes?
Forgive me,
It would sound quite sensible for them to do so.
I shouldn't have said inevitable. Forgive me, my lord, that was overstating it. But it is perfectly possible, and there is no requirement for the parties to have sorted that out before the landlord puts in their first certificate.
Yeah. But the certificate isn't the only necessary trigger for the expert determination.
No.
A sensible tenant might want to say, before I take this obligation on, what is
Indeed.
the proportion of these service charges I'll be paying, and be alerted to the fact that he needs an expert determination long before the certificate is issued.
Technically, the parties could do it before the grant of the lease, but then one would expect to see the proportion actually recorded in the lease. They could do it during the first year or part of a year, whatever is the first period.
Once it's
but equally,
once it's done, isn't it? Subject to
It's a one-off.
any change in the landlord's intention as to areas to be let.
or any change to the rest of the building,
Yes, sure.
which increases the proportion
Yes.
that is the tenant.
Generally speaking, once that's been sorted out for a particular tenant, that's going to endure through a series of annual certificates.
Usually.
Yes, because it's the landlord's intention to let, and unless he alters the building, then, as Lord Briggs says, the expert determination will continue year on year, because a premises may not be let, but if he intends to let them,
That would cover
they
it.
come into the proportion, and presumably, if they're not let, the landlord has to meet that proportion. The proportion of the unlet premises.
Well, query on a very strict reading, a landlord might argue that if it was occupying, that so far as the proportion is concerned, that would not be taken into account because it's only are let or intended to be let. I think, if I recall correctly, it's something that would be corrected then by the excluded costs.
But in principle, intended it to be let is to capture voids.
Yes.
Yes.
So that the other tenants who are there don't have to pick up a proportion of the void.
That was simply my point.
Absolutely.
Yeah.
But if the landlord went in, strictly speaking, the landlord's part would not be proportioned out, but actually when we get to the excluded costs, we'll see it can be taken out.
Well, I wasn't envisaging the landlord
Yes.
going in, I was envisaging carrying the
Indeed.
cost of the void.
But the point, my lords, is the parties did not fix the proportion ahead of the game, as it were. There is a very explicit provision bringing in the detailed provisions which lie in the definition section of expert determination, a long and detailed provision for that and how it works, where the proportions, as the provision provides for, could change and could be first identified by the tenant, by the landlord to the tenant at the time of certification. There is no imperative to not do that.
why, if things happen in that order, would one be unable to say that what may not have been a manifest error at the time of the original certification by the landlord has, once you've got the expert determination, become manifest, so that you're not bound by the certificate at that stage?
Well, you would have to bring it into the notion of it being a manifest error, and I will take you into more detail about that, but that rules out something that requires significant investigation or an exercise of judgment.
But by the time you've got the expert determination, you don't need to investigate anymore. It is clear. I mean, isn't that part of the significance of, although the language in paragraph 2 is fair and reasonable proportion, of it in fact being a mathematical exercise?
Well, my lord, it's not an entirely mathematical exercise to work out the prorated internal square footage.
All right, but once you've had the
Different
expert...
surveyors will come to a different view, and they'll tell you it's an art, not a science.
All right, but once you've had the expert
Determination that fixes a figure at that
fixes a figure. So, and both parties are bound by that. So, why at that stage is that not capable of being a manifest error in the certificate?
My lord, I'd have to accept at that point, then it potentially would be.
But your submission would be from that point on, not from that
Not
point
at
backwards.
the point of the certificate.
Certification.
Sure.
No.
And on the
And
assumption
if the certificate is conclusive, then from then on, until you can point to the manifest error, the obligation to pay and not to set off, etc., are in place.
And on the assumption that your submission that there's nothing to stop the certificate preceding the determination under paragraph 6, if that isn't capable of being a manifest error, then one's concept of conclusivity and manifest error in paragraph 3 has to conform to a notion that a manifest error may only appear later.
Indeed.
This may not be the only example, because it might also appear once inspection of accounts and invoices and so forth has been carried out.
Indeed.
But you're no doubt going to come to that in due course.
Indeed. And then we have to ask ourselves, does the concept of manifest error extend wide enough to cover all those things? Or is the reality that this certification is about the amount, and in our submission, about what flows in the schedule from the certificate, not what ultimately the tenant is necessarily liable to pay once everything has worked through.
I mean, so just to explore a little bit further this timing issue, are you saying that the idea of the certificate being conclusive is something that has to be tested only at the time when the certificate is produced?
My lord, no, we would say the conclusivity of a certificate has to be put in the context of this regime as a whole. And one has to look at the regime and the role that the certificate plays in it, as well as the words of paragraph 3 itself, in order to work out the subject matter, the scope, the duration and the nature of the conclusivity.
It would be easy to imagine it taking a little while for a fraud to be identified and established, and an awful lot longer than the notional dates lying behind paragraphs 3 and 5 of the schedule.
Indeed. But even without those, when I get you to the excluded costs, there are other things that are likely to be time sensitive and not a matter of error, but a subsequent event, which are not taken into account by this certification process. Indeed, it's our submission, and it appears, if I understand my learned friend's case to be correct, that what is being certified as a total takes no account of the excluded costs. That certainly in our submission is the clear language.
But if these
1, 2, and 3.
So if the certificates can in effect be tested for manifest mathematical error or fraud at any point in time, might one look at it as being conclusive of an argument on the basis of one set of information at a particular point in time, which may be relevant to whether money gets paid over at particular points in time, but that later in time something might emerge on the basis of which one can say there is a manifest or mathematical error or a fraud, which then opens up the conclusivity of the certificate. So in effect, although it served a certain purpose at one stage in the life of the lease, that now has to be undone, or it becomes open to the tenant to bring claims based on the underlying obligations in the lease.
Indeed, and that is not the conclusivity that the landlord here seeks, or that the Court of Appeal found. Court of Appeal found that the landlord was right in contending that the certificate was conclusive, full stop, as to the tenant's liability. That in those circumstances, it's determined such that summary judgment can be given the amount that is due from the tenant's liability under the lease.
But if, I mean, just looking at this case historically, you had originally pleaded a manifest error, but the manifest error was denied, then you would have a situation in which it might take until a trial of that claim before it could be established whether the certificate was vitiated by manifest error. It might take years.
Indeed. But if it was a manifest error, in this matter, we pleaded a number of defences based on the terms of the lease, not as manifest error. And the landlord's position is, though, as is ours, that those are matters that are not manifest errors, that they are matters that go beyond the narrow permitted defences, and that in those circumstances, for instance, the matters that are excluded costs are matters that it is not open to the tenant to raise in the face of a certificate.
At all?
At all.
Or save where the
Unless
error is
they can be
manifest?
Brought in by a counterclaim, and there's an argument still to go as to what extent the counterclaims may be open.
But it's easy to think of an excluded cost which is included in the certificate. I mean, you wouldn't know when you got the certificate, you just get a figure. But then when you get the invoices, let's say, that go to back up the figure, you can see that it includes an invoice for repairs on a completely different building. Now, that would be a manifest error. Excluded cost, and it would be a manifest error. But it wouldn't be something you would just see the day you get the certificate.
No, but there are many other things in the excluded costs which would not be apparent from the information provided. My Lords.
No, I was just testing your quite
Indeed.
rigorous submission that there's simply no way in which anything to do with excluded costs could ever be challenged.
My Lord, again, I'm using two absolute terms. There may be an overlap between some items in excluded costs and a manifest error, but it is our submission, and indeed it is the respondent's case, that the manifest error, the permitted defences, are considerably narrower than the arguments that exist, the defences that have been raised on the basis of the terms of the lease as to what actually the tenant is liable to pay for.
I'm not absolutely sure that the Court of Appeal was putting it in quite such absolute terms as you say. I mean, the Court of Appeal seems to have been addressing the situation as did arise on the facts, where your clients had not pleaded any of the permitted defences, but simply asserted a counterclaim.
My Lord, to be clear, I was talking theoretically. I accept theoretically there could be an item of expenditure that was both a manifest error and an excluded cost. But what we say is that excluded costs, for example, are much wider than the things that would be manifest errors. That is the position that is taken in the respondent's case at, it's page 177 in the bundle, paragraph 84.7, where they say what's clearly not permissible where a defendant's ground of challenge is restricted to a manifest error is to do what Blacks did in this case, which is to raise a very wide range of points of dispute and over both general principle and specific detail, supported by extensive schedules.
I think my instinctive reaction to that is depends what the errors were. If you have included an excluded cost, and you'd only find that out when you go behind the certificate to see how it was made up in the accounts, then it might be 100 small items which needed a schedule, or it might be one big item that didn't.
My Lord, in our submission, when we look at the excluded costs, the nature of a number of them is such that they would sit outside of manifest error. So, for instance, it includes things that are caused by the negligence of the landlord. I wasn't going to paragraphs 9 and 10 yet, but it may be sensible if I...
I've got it in front of me.
So, if I turn to that, and then I will come back to the sequencing of payment, which we say is actually what the certification is really about, and is really about, as the respondent says it needs it to be, about cash flow. But if I can look at the excluded costs, paragraph 9, there shall be excluded from the contribution payable by the tenant in respect of the total costs of services and expenses incurred by the landlord hereunder, any excluded costs. And it's interesting that that provides for an exclusion from the contribution payable, not from the total costs of services. One might have expected, if the excluded costs were to be removed insofar as they were known, pre-certification, for paragraph 1 to include reference to them, or there to be a paragraph between 1 or 2 that provided for that calculation to be done before one got to the certificate. Not to have paragraph 1 tied to part 2 and such total costs to feed through to paragraphs 2 and 3.
But how would it work? Because the the contribution payable is fixed by reference to proportions of net internal area in 6.
Indeed.
And is 9 not simply an inelegantly drafted provision, which is saying that the total cost of services and expenses which can be claimed from any tenant have excluded from them the excluded costs, and nothing more complex than that?
I certainly, my lords, would not want to be here arguing that in the context of this regime,
Yes.
the total excluded costs should be deducted from the proportion as opposed to a prorated amount.
Yes.
In the same way as I press the point about the need to look at the regime as a whole,
Yeah.
I would have to accept that point against me if I were trying to.
But I mean, the reference to the contribution payable by the tenant is really OTOs here. On your proper interpretation, there shall be excluded from the total cost of services and etc. and expenses in paragraph 1 the excluded costs. That's really what it's designed to achieve.
Mathematically, that's absolutely what it's designed to achieve.
Doesn't it work linguistically if you say that if it's an excluded cost, it isn't a, quotes, reasonable and proper cost to the landlord during the calendar year ending the relevant date of the service and expenses specified?
Yeah.
Because it's excluded. In other words, the landlord has, when compiling his certificate under paragraph 3 of what he has incurred under paragraph 1, to exclude any excluded costs.
Well, my lord, save that paragraph 3 refers to such total costs that has been ascertained, which is a reference back to paragraph 1,
Yes.
which is very explicit about the subject matter.
That's total reasonable and proper cost. It can't be a proper cost, can it, if it's an excluded?
Specified in part 2. It's very explicit about that. And
So
my
how
lords,
do
we
you-
say
how do
the
you think
answer
this
to this is about cash flow. It is about the timing at which money is paid on account and then released from a separate account, which this regime provides for, so that the landlord has the cash flow that they need. And my learned friend urges is a commercial driver for this regime.
But how do you, does the landlord exclude excluded costs under paragraph 1 or not? Because if he doesn't,
No.
he includes all those costs, then the certificate under 3 is plainly going to lead to the tenant being asked to pay more than is payable.
Indeed.
But that's a very strange
Because
way
it's
of construing this.
what it's certifying is the amount ascertained at that point in the process. At that point in the process, what the landlord is enjoined to do, and one is very clear, there are a number of indicators that it is not engaging in the exercise that my Lord Briggs is suggesting. It refers, I accept, to reasonable and proper cost, but the subject matter of that is the services and expenses in part 2 of the schedule. We then have the bracketed words, excluding costs and expenses met by insurers under the policy of insurance affected by the landlord. And this is happening as quickly as possible after the close of the calendar year. As quickly as practicable. So it's a headline figure.
You say that's picking up a particular excluded cost.
At that point. Or it may well be. And we see the importance of the process. So at paragraph 4, we have the tenant paying a sum on account, which although it refers to the certificate, to the first certificate, in fact, when you read that provision, the payment on account is simply of a quarter of the sum estimated by the landlord for the year in question.
For the year ahead?
The year ahead.
Yes.
So there's an early payment on account. At paragraph 7, we see that the landlord must place any sums that are properly applicable to the total costs and services incurred by the landlord in any year in a separate interest-bearing account until they are needed to meet those costs, and any interest earned on that account shall be applied to that.
They're placed on deposit?
Yes. So they're paid up front, which gives an assurance to the landlord, and they're available when needed for the particular works, costs and expenses that they were estimated to relate to. Then when we go to 5, as soon as the certificate of the landlord for the year in question shall have been furnished, the landlord shall apply any sums paid on account of the further rent, and not so previously applied by virtue of this provision, in and towards the discharge of the liability of the tenant in respect of further rent. And on the quarter day following the furnishing of such certificate, any difference between the sums paid on account and the sum payable by virtue of the certificate shall be adjusted by payment. So there's a payment on account on deposit that can be drawn against when needed. We have a certificate as early as possible or as early as practicable after the close of the year, which does a headline amount and proportion, and then a release of money from the deposit that is not held back on the basis that the need has not arisen. It comes to the landlord for the landlord to hold and have available.
So the landlord may make a payment back to the tenant, or the tenant may be required to make an additional payment?
Depending on what the amount in the certificate is.
Yeah.
But it is what is payable by virtue of the certificate as opposed to what the tenant may or may not be liable for ultimately under the terms of the lease, which would have to take account of the, for instance, excluded costs, which have not been built in our submission to that process so far. And the excluded costs cover things like any part of the building that the tenant or other tenant is wholly responsible for, any sums that the landlord recovers or is met under an insurance policy of insurance maintained pursuant to the obligations of the lease, or it recovers in whole or in part from any person other than the tenant or another tenant of the building. Now, those sort of recoveries are things that may take some time, may take some considerable time. So in terms of cash flow, the fact that they sit outside the certificate absolutely gives the advantage that the landlord says we need. We have an estimated sum that can sit and be drawn down against in relation to the works that were estimated in relation to when it's needed. We have a headline sum that we have certificated, and against that the monies can be released and a first adjustment can be made. But the fact remains that if insurance money comes in 6 months, a year later, then that is an excluded cost. That is ultimately not something the tenant is liable for under the lease. If the costs were caused or necessitated, 10.3, by the negligence of the landlord or its servants, that is ultimately not something the tenant is liable for under the lease. But that is not going to be something that is clear or obvious, that can be ascertained without investigation or an exercise of judgment by parties and potentially a court further down the line.
Well,
and this is what is happening here.
I mean, it might be if, for example, the landlord included a cost of doing some repair that a year later it recovered from another tenant, so it became an excluded cost. That would presumably show up in its accounts, its books and records, which it's obliged to reveal to the tenants under paragraph 11.
This
or
landlord
if it made an
says,
insurance recovery.
this landlord says, you can't say I'm not liable for that sum because the certificate is conclusive against you.
Well, subject to manifest error, and if the accounts showed, for example, that the landlord had made £100,000 insurance recovery, but after the date of the certificate, in relation to costs which it included in the certificate, it would be one of those examples where an error, albeit later in the day, becomes apparent.
Well, but it wasn't
manifest at the moment, but it becomes apparent.
It wasn't an error in the certificate.
No, at the time.
And my understanding, and my learned friend will correct me if I'm wrong, is that their position is that's it, it's done, it's conclusive of the liability.
At some point, the manifest error there must be a line.
Yes.
But one might say, well, if it's as flexible as is being put to you in the course of your submissions by way of question, it will be manifest once negligence is established.
Yes.
So where does one put the line?
If it's
at what point do you determine whether or not an error is manifest or not? Because at the end of the day, any error may be manifest once the court process is concluded.
if you are allowed access to that. And at a point where one is alleging negligence, we would say you can't really be alleging manifest error, that they are not things that sit in the same space. They're very, very different concepts. And perhaps if I leave Schedule 6 reluctantly and go to...
But why couldn't it become manifest later, as my lord put to you? I mean, it might be said that there is an analogy with paragraph 6 and the expert determination.
The difficulty is it might become manifest when you have your judgment.
Yes.
But it's not before that.
Yes.
So you can't allege it is before it's manifest. If the reason it's manifest is because you have a judgment and you have certainty and clarity and there is no longer an investigation and a judgment to be made, you don't get to that point because you can't say this certificate is not conclusive on this point because there is a manifest error. No, I'm alleging negligence. I want to run my negligence claim. If it's not manifest until a judge has decided they were negligent and it caused this loss, I can't allege in the pleading that it is manifest when it is clearly a matter of argument and evidence and expert evidence with different experts expressing different views.
And which it would be, certainly I would be grateful for your assistance as to which of the various elements of the excluded costs in your submission do not lend themselves to a manifest error analysis.
certainly we would say that, forgive me, the parts of 10.2, so recovery from other persons or other tenants, so there may be a situation where there's been negligence by a contractor, and again, there'll be a landlord's potential claim which is arguable and a matter of evidence, etc., as I've already referred to. 10.3, the landlord's own negligence. And certainly 10.7, the cost of any improvement, modernisation and refurbishment, which is complicated by the law in relation to the division between repair and improvement, as is reflected here. So you exclude the cost of any improvement, modernisation and refurbishment, but not the cost of repair, which shall include where repair is not economically viable, replacement by material or product of similar specification. So again, there is a question of expert evidence and judgment as to whether the ostensible improvement, modernisation or refurbishment would fall within that exception because it was the most and only proper economically viable way to address the underlying disrepair rather than constantly be repairing.
I want to understand what you're saying about 10 before you depart from Schedule 6. Are you saying none of the excluded costs come into play at all before the certificate's issued? You said earlier excluded costs aren't built into the process so far. I mean, some of them, for example, the adoption of roads must be absolutely obvious to the landlord, or the provision of apparatus or works incurred before the date of the lease. Again, surely these would be things which the landlord should exclude from his certificate at the outset. Some of those, I've highlighted the ones that is very unlikely would be known at the end of the year, in the year in which they happened, but many of the others may well be known within the year. But paragraphs 1, 2 and 3, when you follow them through, do not require the landlord to strip those out of their total costs of services and expenses in Part 2. And it's very specific about that. And there's...
Well, I respectfully question whether that is right. I mean, because I wanted to ask about paragraph 5 as well, where I think you were emphasising, well, the sum which the tenant, additional sum the tenant may have to pay under paragraph 5 is by virtue of such certificate, and on your approach, that may include a calculation which has included excluded costs. But in fact, paragraph 5 is framed in terms of applying the money towards discharge of the liability of the tenant. I mean, that seems to be looking at the actual, in principle, liability of the tenant under the lease, not some notional liability created just for the purposes of the certificate.
Well, save that it does refer to sum payable by virtue of the certificate. So one has a notion that the certificate creates a payability. Right,
but one might say that the fact that what is referred to in paragraph 5 is using monies towards discharge of the liability of the tenant and then top up or repayment back tends to align the notion of certification with what is the obligation of the tenant under the lease, which would exclude excluded costs.
My lord, I'd have to accept it can be read that way, our submission would be, when you look at it as a whole and it being very specifically attached to the certificate and triggered by the certificate at that point, and bearing in mind that many of the items for instance, the excluded costs are unlikely to be known at that point, certainly at the point of certificate, and quite possibly even when one looks at 8 and 11, not necessarily known or determined within the timeframes of those.
But I mean, if it can be read in that way,
read.
what's the logic of saying that the certificate is prepared, including excluded costs, which everyone knows in principle are excluded costs and ought to be taken out? It's true there may be some uncertainty about what the amount of those elements are, but if you have sufficient certainty at the outset...
Obviously, a landlord could always elect to take them out.
But he wouldn't. I mean, he'd want as much money as possible. But I come back to my question, what's the commercial logic of letting him do that if he knows that he's charging for something which is an excluded cost?
Because, my lord, the landlord's position is cash flow is crucial. I am having to lay out money to pay for my obligations under 5.4 and under Schedule 6, Part 2. I need to know that the money is coming. I need to know it's there. I need to minimise the disputes. There is a balance to be struck in that. And our submission is that the payment on account, the certification of what I have referred to as the headline at the end of the year, and the release and balancing on the basis of that, is providing that cash flow and putting the landlord in a position where they have that comfort and that ability to keep functioning. What it does not do is operate as a conclusive determination of what the tenant owes for that year's service charge, further rent, under the terms of the lease as a whole. For it to do that would be, in our submission, a very unbalanced arrangement. One would need to see clarity that that's what it was doing. The certification provision doesn't refer to the exclusion of costs, the excluded costs. It doesn't refer to the further rent payable under the terms of the lease. It doesn't refer to clause 2.3d. And we have the concept we see in 5 of a sum that is payable by virtue of the certificate. So it is providing another step in that cash flowing that the payment on account does, but it is not conclusively determining for all time what the tenant's liability for that service charge year was under the terms of the lease.
Just to understand the mechanics of your submission, you're saying clause 1, paragraph 1, refers to the costs incurred providing the Part 2 services. And then if you turn to the Part 2 services, there are various specific services, but there's a catch-all in 13, providing all and any other services by the landlord acting reasonably in the interest of good estate management.
Indeed.
So you're saying that am I right? You're saying that captures everything, and you then have to address the excluded costs.
Yes. And pull them out later, separately, when you're in a position to do so, when they can be evidenced and proved, but not at the expense, under this regime, of the landlord's cash flow.
So the landlord can claim for can require a gross sum and can estimate at the start of the year that he's going to be spending a gross sum. But what ultimately is payable by the tenant, you say, is a later exercise once the excluded costs have been ascertained.
Yes, once you're in a position to do that. And so in the context of this case, to shut out defences that go to costs that were caused or increased by the landlord's negligence, costs that are works of improvement, is to run entirely counter to the terms of the lease, clause 2.3d, which provides that the tenant's liability is that under the whole of Schedule 6, in accordance with Schedule 6, and the very clear exclusion in paragraphs 9 and 10 of items such as that. Seems sensible to take your lordships to the meaning of manifest error. Mathematical error, I think, probably needn't trouble us too much.
May I just ask you, please,
etc.
May I just interrupt you for one moment, please, and ask you, in the context of this overall scheme that you're describing, how 8 and 11 would work?
Certainly, my lord. Sorry, I was going through in order, I lost track. So far as 8 is concerned, that provides for the retention of all receipts and invoices. So, sorry, start again. 8 is notable. It's a 12-month period triggered by the certificate, but it's making available all receipts or invoices or other satisfactory evidence, and it reflects the language of the certificate evidencing the total costs and services incurred under this schedule and evidencing the contribution to such payable by the tenant and they're delivered on request.
And in relation to the second half of that,
just before we leave that, sorry,
what would the second half of that cover? Evidencing the contribution to such payable by the tenant on request by the tenant.
So, first of all, the incurred will be receipts and invoices of everything that the landlord has spent.
Yeah.
And the contribution payable will be anything that goes to the proportion, and it may, if they already exist, sweep up some elements that go to the excluded costs.
Sorry, so when you say sweep up some elements, you mean you exclude excluded costs at that stage? Is that what you meant?
My lord, we would say yes, it's not talking about the excluded costs at that stage, because if we look at where contribution, evidencing the contribution to such payable, where it is used in this scheme, it is before and without regard to the excluded costs. So we see it in 6 and we see it in 9 as the description of what you take the excluded costs away from.
But I mean, might it not be said that that second part of paragraph 8 is looking to the true contribution due from the tenant in principle under the lease? In other words, to take account of where you get to after excluding excluded costs.
My lord, certainly it could be construed that way, because we have language that throughout this scheme has some capacity in places for more than one interpretation. And the point is, my lords, when we're looking at Schedule 6, which was described in Clause 3.6 as helping us with how the service charge was calculated and payable at the times and in accordance with the schedule, we've got a lot of moving parts and purposes for which different elements are occurring. But we would certainly say when you look at paragraph 8 and paragraph 9, the contribution payable by the tenant in respect of the costs and services incurred is something that you then take, that's something that comes before the removal of the excluded costs.
May I ask, in relation to that second half of paragraph 8, how would it work in practice? I mean, the landlord isn't going to be separating out documents that relate to excluded costs from others. I mean, the landlord would simply have documents relating to the contribution which each tenant must pay.
My lord, and that is rather the point. Certification is of what the landlord has spent. The landlord under 8 will be providing all the invoices and receipts in relation to the monies it certifies it has spent. It is not required to remove from those receipts and invoices for work that were caused by its own negligence. And one wouldn't expect it to.
So I think I understand your general scheme is you get a certificate, you're the tenant, which includes everything.
Yes.
The landlord's under no obligation to cut out of that certificate excluded costs.
They might, but they're not
There's not
obliged.
any obligation to do so, but you say, although not spelt out here, there's a third stage in this process. Because one assumes this doesn't all, it's not intended this should be the subject of litigation every time it arises. No. There's some third but unspoken stage in this process where the landlord then goes through the books and records again, pulls out the excluded costs, and sends another statement to the tenant saying, well, whereas you had to pay X amount on my certificate, I now pay you back Y amount. I mean, it'll always be a payback if what the landlord's doing is stripping out excluded costs. So there's sort of later but wholly unspoken provision here for a payback by the landlord to the tenant of the excluded costs element that was included within the certificate.
My lord, to put that in context...
I'm not saying that's impossible, because some of it become apparent after the event.
To put it in context, the excluded costs are not by their nature something that's going to be happening every year.
Might another interpretation be that the landlord makes a judgment about what is excluded or not, and at the end of the year, in the certificate, takes that into account. But when the documents become available, that judgment may not be something that you agree with and something that you want to challenge. And there may well be circumstances where the excluded costs are not immediately obvious from the documents which are disclosed, but so as to amount to a manifest error, but which are something which you say properly ought to have been deleted and can only be assessed once the matter is properly tested.
My lord, the difficulty with the position taken by the landlord and the Court of Appeal in relation to that is it doesn't get to be tested.
Well, I understand that, but I'm
putting a matter of practical reality.
Yes, I understand your but I'm putting to you a possible alternative approach to the interpretation of the agreement, which may be consistent with the case you're ultimately advancing, but doesn't require you, so to speak, to take on the points which my Lord Briggs is putting to you, because the landlord can properly and may be expected properly to take into account those excluded costs which it considers should be deducted at the time of certification. But that may be something that you don't agree with.
My lord, certainly we would not suggest there's any bar to the landlord doing that.
Yes.
But what in our submission is clear is that the lease is not actually demanding that the landlord does that.
Right.
But if
whether
the
or not
if the landlord is 90% sure that a cost is an excluded cost, let's say it's covered by an insurance policy, the insurers haven't challenged liability, it's been paid yet. For the landlord to include it having incurred that cost, where it knows it's going to get an insurance recovery in a fairly short time, within the certificate, would seem to run counter to paragraph 9, which talks about excluding from the contribution payable by the tenant in respect to the total costs and services any excluded costs. Now, that's, one would have thought, a reference back to the provision in, for example, paragraph 5, rather than to some notional later finalisation process which isn't referred to in this schedule at all.
My Lord, the difficulty is with some of these items, some may be known
Yes.
at the end of the year, some may be known within the 3 months in paragraph 11 or the 12 months in paragraph 8. Some may not be known for longer. Some may be a matter of dispute. The regime with the conclusivity that is contended for by the landlord strips paragraphs 9 and 10 of their meat in any instance where the excluded costs are not well known and clear, so that there is not a matter of argument at the date of the certificate.
May I ask you, please, also to assist us in relation to paragraph 11 and how that relates to 8 and what each is doing?
My Lord, it appears to be making a wider obligation to show and tell, if I can put it that way, for a shorter period. So we would say 8 is very much geared towards, although it may well give you information that goes beyond this, towards the certification of amounts that is called for by 3, because what is to be disclosed is receipts or invoices or other evidence of the things that certification relates to.
And can I just check the relevant statement, is that the certificate?
There doesn't seem to be any other use of statements.
No,
it's hard to understand.
Because 8 is quite differently worded in that respect.
Indeed.
It talks about a time limit that starts to run from the date of the certificate. So one would prima facie think that the relevant statement might be something different under 11, though I'm lost to think what it could be.
Yes, and unfortunately there isn't a other use of statement that I've been able to find which would help give us a clue on that. So we would say 8 is something that is geared towards what Master Bartlett called the accounting exercise. Mrs. Justice Bacon referred to as the certification of the amount of the total cost and the sum payable. So the amounts, here are the invoices or receipts or equivalent evidence. You can see how the figures were generated. You can see how the amounts were arrived at. 11 is a shorter window in terms of time, but in terms of the material that has to be made available is much wider. Books, records, and accounts, which will show much more about what may be the future events, for instance, insurance claims that are outstanding, monies that might be recoverable from third parties and the like. So we would say that is ability to access information that goes beyond the mathematical and manifest error and gives some check and balance in terms of what is happening around things such as the excluded costs.
Could I, apologies, ask you to go back to paragraph 8?
So,
I just wanted to check what is being covered there. So the landlord, for the period of 12 months after receipt of the certificate, and the certificate is referring backwards to a calendar year.
Preceding year.
But this is looking for the period 12 months after the certificate.
Yes, so certificate for December 20, for the year ending 31st of December 2020, you can call right up till the 31st of December 21 for the receipts and invoices.
Now, in that 12-month period, after the certificate, various things may have become clearer as to whether there is an excluded cost or not. For instance, an insurance claim may have been paid, which in principle moves something from the a recoverable element from the tenant into the excluded costs column. The things which have to be made available are things which evidence the total costs and expenses incurred by the landlord under this schedule. So that does seem to refer back to what has happened in the preceding calendar year, culminating in the certificate, but then evidencing the contribution to such payable by the tenant. Now, as I understand your submissions, you're saying, well, even if at that point it's become clear and the landlord has sitting in its documents and records covered by this provision that say an insurance claim has been paid, that you still leave that out of account. And I just question that.
No, my lord. Our position is that if it's clear by then, if it was always the case that it was coming but the tenant didn't know, then what's actually payable under the lease, under the terms of the lease, would have to take account of that.
Right.
By virtue of the excluded costs. But the certificate won't have. And the certificate...
the paragraph 8 is, you seem to be making a lot of the order in which one reaches these paragraphs in the schedule. This is what I understood you to be saying, and that you only get to paragraphs 9 and 10 after you've gone through the whole certification stage. But paragraph 8 is before paragraphs 9 and 10, and now you seem to be saying, oh yes, you do take account of additional information which may show that something is in fact an excluded cost, even though that couldn't have been known at the time of the certificate or known for sure.
My lord, I'm sorry if I'm not being clear. What we are, the certificate has to come early in the following year.
Yes.
As soon as reasonably practicable. It is said to be conclusive.
Well, yeah, conclusive, let's say, subject to manifest error, which may appear later on.
The permitted or reserved defences. The paragraph 8 is looking at that previous year that has been certificated and calling for receipts, invoices, and other evidence in relation to those things that have been certificated. The amount of the total costs and the amount of the contribution payable.
So, but that's precisely what I was questioning. Paragraph 8 isn't confined to material specifically arising in that previous year.
Not material that was created in that year, but that relates to that year.
Right.
So there may be something, my lord, which I think is your point, and if I've misunderstood, I'm sorry, a document that comes into existence after the 31st of December.
Correct.
But that relates
Lord
to
Briggs. Briggs example of the insurance claim which
Yes.
is paid. You get the cheque that has,
Yes.
sorry, it's showing my age, you know, the payment comes in, there's
Mine too.
a documentary record, makes it perfectly clear, this claim was made,
Indeed.
it's now been paid. That's all happened within 12 months after the receipt
In
of
that
the
case, you would
certificate.
get that.
Right. Right, thank you.
But, okay, there isn't any express provision here for prior year adjustments. The way this thing appears to work, in terms of what's express, is that you'll know what the excluded costs are, it'll all be dealt with, and it either will be dealt with, you say, in some process following the certificate, or I think your opponent will say, actually, if it's an excluded cost, it won't appear in the certificate at all, it'll be dealt with up front. But there's nothing here that says in terms what happens if a landlord, let's say genuinely and without fraud, thinks that he's not going to make an insurance recovery in respect of a particular item, but he has a go at the insurers nonetheless, and so he includes that cost in the certificate, and let's say a year and a half later, even after this 12-month period has expired, the insurers have a fit of generosity and pay up.
Indeed.
Surely, well, I ask you, is it not implicit that in a situation of that kind, there'll be some obligation on the landlord to pay back?
My lord.
I'm not quite sure how it works, but
Well,
it seems to me as a matter of common sense and ordinary business decency, if a landlord discovers that his certificate is in fact falsified by a subsequent event, he is obliged to deal with it.
my lord, can I come at it from a slightly different angle?
Yes.
Bear with me. If there was no certification, there would be an estimate, there would be a payment on account, there would be a statement that is not certificated at the end of the year saying this is what you owe, and with access to information which we have of the type of paragraph 8 and 11, a tenant may say, I don't think I owe all of that for this, this and this reason under the terms of the lease. And then there is a dispute and the court will determine that. In our submission, that is what happens here, but there is slotted in an extra stage of the certification of amounts which give an extra cash flow benefit to the landlord of the sort I've described. But it doesn't take away the ability of the tenant, as any other tenant, to say, you're saying I should pay that, but actually, under the terms of the lease, I'm not obliged to pay that because you're recovering it from an insurer, because it's caused by your negligence, because it's an improvement. And my lease explicitly says I don't have to pay for those. And that's the simple point. Whether this paragraph 3 certification clause intervenes to strip out the effect of the other clauses in the lease, which are straightforward provisions as to what the tenant is and is not liable for. I don't know if that helps, my lord.
Yes, thank you.
Well, certainly at some point I'd be grateful for your assistance as to the relevance of the manifest mathematical error or fraud restrictions in the context of your submission as to how the lease works.
Yes, my lord. My lord, would it be helpful if I take you, flow group, we would say, really is where we are now with manifest error. Bear with me while I just find my page reference.
Yes, I think we better let you move on to manifest error because time is passing.
Yes, I'm very conscious of. Sorry. It's page 782. don't know if your lordships are familiar with this authority. Concerns. Do your lordships prefer to read a head note yourselves?
It'll be quicker.
It's page
782.
782. My lords, and then if I can take you to 788, starting at paragraph 12 is the section where Adrian Beltrami, KC, as he now is, deals with manifest error. And if I can just skip through the key passages.
Paragraphs.
It starts at 12, the section on page 488.
So in 788.
And he takes a journey through Amy Birmingham, Viva Oil. So I'm trying to deal with this in order to make it a little quicker. And so in paragraph 12, the parties are in dispute about the meaning and application of manifest error, the manifest error exception. This is in the context of an expert determination, but it's obviously the expression that's used for our certification. There are two aspects to this. As to the meaning of the exception in general terms and its application, where an expert's determination itself involves a question of contractual interpretation. So we're really focused on the first one. Paragraph 14, referring to Amy Birmingham, on behalf of the seller in that instance, Mr. Cohen, KC, described these words as noting a visibility test in the sense that the error must be capable of being, as he put it, demonstrated from the face of the record. On this basis, it would not matter how complex or difficult the question was, as the error would be manifest if it could be shown and set against the correct answer. And then he goes on, demonstrating that it moved on a bit, was not quite that narrow by the time we get in paragraph 15 to Lord Justice Simon Brown in Viva Oil, where the developing description was given by Mr. Justice Morrison and as Lord Justice Simon Brown offered what he described a definition of manifest errors as being oversights and blunders so obvious and obviously capable of affecting the determination as to admit no difference of opinion. Mr. Pooley submitted that manifest error must be more than just a wrong answer. It must be described as a howler. And then at paragraph 17, I consider that the Viva Oil test identifies an important and necessary component of manifest error exception. It's not been subsumed by the visibility test advanced by Mr. Cohen for the following reasons. First, I was shown no case in which Viva Oil was disapproved. Second, he then refers to two cases with a similar approach, where description by, as he then was, Mr. Justice Thomas, was obiter, that it was not enough for the purchaser to show that their interpretation of the agreement is right. They had to show that the expert's interpretation was obviously wrong. He then moves on at paragraph 20 to look at the textbooks, Lindley and Banks, as it then was the 2020 edition, citing a passage from Lord Lindley, referring to manifest error in partnership accounts. All errors are manifest when discovered, which is important here, was my point earlier, but such clauses as those referred to here are intended to confine to oversights and blunders so obvious as to admit no difference of opinion. And then referring to the 7th edition, which I think is the one we have in the bundles, of Lewison on the interpretation of contracts. A contract will sometimes say that a certificate is binding save as to manifest error. The expression of manifest error refers to oversights and blunders so obvious and obviously capable of affecting the determination as to admit no difference of opinion. Footnote reference to Berber oil, or one that is so obviously or easily demonstrable without extensive investigation.
And if one goes all the way down to the end of 21...
My lord, you're ahead of me.
There's some scope for thinking that the precise meaning of manifest error will take its flavour from the context.
Some.
Because the particular reference is made here to the importance of not going behind a party's bargain
Indeed.
to have their dispute adjudicated by an expert, for example.
Indeed.
And I'm just, at the speed which we're rushing through this, it's not too clear to me what the context of all these cited cases may be. They're not all apparently about expert certification, so it looks
Not
like
all.
most of them are.
Most, but not all.
I mean, that clearly is the context for this case, and one might think that's very important because it's supposed to stop with the expert. So you get the expert's opinion, that's supposed to be the end of it, subject to manifest error on the face of that opinion. But in our case, things are moving on beyond the production of the certificate. I mean, one sees it moving on in terms of provision of information, paragraphs 8 and paragraph 11 of Schedule 6, and in terms of events happening which affect the tenant's contribution. For instance, things occurring, like my lord's example of the insurance payment, which makes something into an excluded cost. So the certificate in our case is not intended to be as final as an expert's certificate would be, is it?
My lord, and that's rather the point. When one starts looking at all these possibilities that of items that under the terms of the tenancy the tenant is not liable to pay for, which may be something that simply by virtue of time does not become clear, manifest until later, but may be at the other end of the extreme, a matter of dispute, a matter of expert evidence and consideration. Those items are not something that realistically, when one looks at this regime, one can construe this certification provision as seeking to make a conclusive decision about. So I come back again to the difference between the two competing understandings of the natural words, or the natural understanding of Clause 3. In the Court of Appeal, as he then was, Lord Justice David Richards described the crucial words in Clause 3. The judgment starts at page 192 in the bundle, and I'm going to page 196 at the bottom. I part company with the judge. It's referring to Mrs. Justice Helen Bacon. The first step of her reasoning you can see over the page, he describes the crucial words in paragraph 3 as, on any basis, this comprises at least two elements. One, the amount of the total cost, and two, the sum payable by the tenant. So his natural meaning removes the amount detaches it from the second element, the sum payable, and then says, well, of course, that's deciding liability. Both the Master and Lady Justice Callum Bacon treated amount as applying to both the figures, as Lord Hamblin earlier referred to. There'll be two figures in the certificate, and the amount is what is being certified, not the liability. So early calculation, certification of the amount in that liability, the amount of those two elements, but not a liability. And in our submission, mathematical error, manifest error, fraud is obviously a different matter. That will always unravel anything. But those do not speak, even in this context, to anything like wide enough scope to leave intact the explicit, detailed provisions of the lease about what the tenant is actually liable to pay. Most obviously in the case of the excluded costs. And it's interesting that having concluded that the second part of the certification does not relate to the amount, but to the actual liability, the sum payable by the tenant, not the figure, but the underlying liability. Even the Court of Appeal accepted that that was subject to paragraph 6, because I come back to the point that there's no requirement that any dispute about the proportion has been seen through by the time the certificate comes out. Which again, in our submission, it's subject to 6, it's subject to 9 and 11. It is conclusive as to the figures, the calculation, the amounts, and the sort of reserved defence of mathematical manifest error is appropriately framed to protect the value of the certificate in its role as a stage that enables the cash flowing and the movement towards a resolution, but not the determination of the liability of the tenant across all the provisions of the lease that are relevant to the service charge.
On your approach, the conclusive nature of the certificate under paragraph 3 would entitle the landlord to operate paragraph 5.
Indeed.
And take further money from the tenant based on his certificate.
Until the tenant can come forward and say, actually, I have a defence.
But you say that thereafter the tenant can come up with a defence including excluded costs.
Indeed. And conscious of the time, my lords, I think I technically have 8 minutes. Is there anything?
You do technically have 8 minutes, but you can, of course...
Stop early.
You
Clear, what exactly?
stop early or eat into your reply time.
What's your case on manifest error? You showed us flow group. Can you just...
My lord,
Identify
we
proposition.
say flow group gives an accurate description that it is contained and limited to things that are obvious, that are capable of being identified, and determined without there having to be a difference of opinion, without there having to be an investigation. So when we, to take the extreme versions, when we get to costs that have been caused by the negligence of the landlord, that is an obvious example of something that is way beyond. That there may be an obvious error because by the time of the certificate, the landlord has failed to take account of an insurance payment that's come in. That would be an obvious error. So there may be things in the excluded costs that were obvious, but there is clearly an awful lot beyond.
It may be said that your submission proves too much in the sense that paragraph 3 is only designed to be conclusive for the purpose of triggering a payment under paragraph 5, after which everybody is free to argue the toss until the cows come home. But it's difficult to see why in that case they even included mathematical error, manifest error or fraud, because all you get, if you're the tenant, is the certificate. It will just have two figures, the total cost and your share of the cost, and nothing else, and you're immediately obliged to make the balancing payment. The liability to make the balancing payment is, I think, under paragraph 5, as soon as the certificate shall have been furnished.
My lord.
So whereas one would expect that the sort of errors which were mathematical or manifest errors, or let alone fraud, would only become apparent as a result of a fairly careful inspection by the tenant of the landlord's books, records and evidence thereafter.
My lord, of course, the reality is the certificate will come. A lively tenant, if I put it that way, will ask to see the documents. The landlord will be saying, pay against the certificate, pay against the certificate. And if there is anything that is obvious, that is a mathematical error, that is apparent on the core documents of what has been expended, which is another way that Master Bartlett described the conclusiveness.
I was wrong. It's the next quarter day, isn't it?
Yes.
The tenant has to pay.
So there is that bit of time where the tenant says, no, you've got that wrong on your own documents. But that is a whole different thing from the myriad of other elements under the terms of the lease that the tenant may not in fact be liable for, and that may not become apparent for a significant period of time. And they, in our submission, sit outside those permitted or reserved defences. My lord, I'm just being taken back to exchanges that we had, I think, particularly, my lord, Lord Sales, with you, around the proportion changing. I gave a number of examples where that may change. I'm reminded by my junior that actually, under the RICS rules, the basis and the way in which the internal area is calculated on occasions changes anyway. So that would be another reason why it might not actually, having been done once, remain. In this lease it would have done because it was a one-year lease, but in the earlier ones, not necessarily. My lords, I'll rest there.
Thank you very much. Mr. Fowler.
I'm conscious that a break for a short adjournment will come upon us in about 30 minutes. What I was proposing to do to start with was to summarise the landlord's case quite briefly and to start looking at the relevant provisions of the leases, and also perhaps to look at the certificates which are in the bundle, and that might, I think, assist the court. And after the short adjournment, I'd propose to look in greater detail at the provisions, also at some of the authorities and also at the factual background. My Lords, the appeal, I agree with my learned friend, it concerns a fairly narrow point of construction. There are, of course, two leases in play here, one from 2013 and the second a reversionary lease from 2018 between my client as landlord and Blacks as tenant. In my submission, the key factor here is the interplay between two provisions. The first is the certification provision, to which the court has been taken several times. But I would want to repeat the precise words of that provision. The landlord shall, this is at page 566, paragraph 3. I ought to add that there is a selection of terms from the 2013 lease at page 365 and following. I've been working from the full lease at page 505 and following. I was proposing to use those references for convenience, but I can.
I mean, are they identical?
They are identical. It's just that the earlier extract just extracts some clauses from the lease.
Yes.
But the full lease is at 505 and following. And so at 566, paragraph 3 of part 1 of Schedule 6 of the 2013 lease, the landlord shall on each occasion furnish to the tenant, as soon as practicable after such total cost and the sum payable by the tenant have been ascertained, a certificate as to the amount of the total cost and the sum payable by the tenant, and then, in the absence of manifest mathematical error or fraud, such certificate shall be conclusive. The second provision I want to emphasise at this stage is the no set-off provision, clause 3.1a, which is at 520 to 21. And by that, Blacks covenanted not to exercise or seek to exercise any right or claim to withhold rent or any right or claim to legal or equitable set-off or counterclaims as required by law. Now, in my submission, it's important to remember that the Court of Appeal gave my client summary judgment on its claim without a stay of execution, which judgment was satisfied by the tenant, but didn't feel able to determine the counterclaim. And the Court of Appeal remitted that to the Chancery Division to determine whether any of it could survive summary determination of the claim. So really the issue here is whether we were entitled to summary judgment on our claim, and thus the practical question is what gets remitted to the Chancery Division. Is it just the counterclaim to see if any of it survives? Or if my learned friend succeeds here, does everything go back to the Chancery Division for trial of the entire claim and the counterclaim? Our case, in summary, is that, well, one could summarise it as follows. The first proposition is that, and I don't think this is controversial, rent in the no set-off provision includes service charge. That was fiercely argued before the Deputy Master, who found that it was rent.
Well, I think Lord Sales raised that earlier, and the concession has been.
I'm most grateful. Yes, of course. There seems to be no real dispute about the no set-off provision now, and accordingly, as your Lordship sort of seen, we only dealt with it fleetingly in our case. It was a little more of an issue in the Court of Appeal, and if it would assist, it may help in due course to look at what we said about it previously. But what we say the consequence of this is that Blacks cannot withhold set-off against or counterclaim against service charge. And this applies, we say, on the true construction of Schedule 6, both to certified service charge and to uncertified sums payable on account. And we'd look at we point to paragraphs 2, 3, and 4 of Part 1 of Schedule 6 on that. It's page 566. What is said in paragraph 2 is that the further rent payable by the tenant shall be a sum equal to a fair and reasonable proportion of such total costs. Under 4, the tenant has to make payments on account of the said further rent, and the sum payable in paragraph 3 is ascertained and is then certified. And we say sum payable and sum payable by Blacks and further rent payable by Blacks are the same thing.
And how does one calculate the payment on account?
Well, that's set out in paragraph 4. The tenant shall pay to the landlord on account of the said further rent on the execution of each succeeding quarter day, so every quarter until the first certificate. Such summers shall be notified by the landlord to the tenant in writing, and thereafter on each succeeding quarter day, a sum equal to 1/4 of the sum estimated by the landlord as being the service charge for the year in question. So the landlord makes an estimate at the start of the year and charges 1/4 of that each quarter. And then at the end of the year, as soon as practicable, the landlord certifies.
Can I just raise one thing which is troubling me a bit?
Oh, yes.
There's nothing in this machinery, is there, that requires or makes it inevitable that the landlord will serve the paragraph 3 certificate before the first quarter day after the year end. What it says is, it doesn't say as soon as practicable after the year end. It says as soon as practicable after such total cost and the sum payable by the tenant shall have been ascertained. Now, let's say there's a very large outstanding insurance claim, and you're advised you've got a 50% chance of winning it. Why might it not be appropriate to go on estimating? You'll already have had 4 payments for the year in question on account based on your estimate, until that big uncertainty which stands in the way of ascertaining what is really payable by the tenant has been sorted out.
My Lord, yes, that does appear to be what paragraph 3 does, because it's the date is as soon as practicable after the ascertaining of the figure, rather than after the end of the service charge year.
I think I've been working up until now on the assumption it was as soon as possible after the year end, but not actually what it says.
That also ties into paragraph 5, I think, because the balancing payment that goes either way, when the estimate is compared with the certified sum, is due on the quarter day after the certificate, not on the quarter day after the end of the service charge year.
Yes. So it could be served, let's say, between the summer and the autumn quarter, in which case the balancing payment will be in the following year, and it will be due in the, assuming we're dealing with calendar years, and it would only be due some period thereafter. It might be very soon thereafter, because the landlord could serve it a couple of days before a quarter day.
My Lord, yes. I mean, that does seem to be permitted by the provisions. Though, of course, and I'll come on to these points later on. Paragraph 8, the chance for investigation by the tenant is triggered by receipt of the certificate.
Yes.
So that 12-month period starts then, but it doesn't seem to be the case that the tenant the tenant can raise no challenge or make no investigation before that, but clearly the obvious time to do it would be after receipt of the certificate.
And in a nutshell, is it your submission that the same applies to 11?
My Lord, as my learned friend said, it is slightly odd that paragraph 11, clause 11, uses the phrase relevant statement. But it does refer to the books, records, invoices and accounts relating to the same included in the service charge certificate. That either suggests that the 3 months are triggered by the service charge certificate, because on that basis, relevant statement would be referring back to service charge certificate. I suppose the other possibility would be that it's 3 months from a quarterly bill, but that on account, but that's not clear from the wording of paragraph 11 as it stands.
And in your submission, what does it mean then?
Well, in my submission, it's 3 months from the service charge certificate.
I just wondered whether it's wider than certificate to carry in the notification in writing that's referred to in paragraph 4.
My lord, yes. Yes. It's interesting that notification isn't referred to in paragraph 11, but relevant statement may be wide enough to encompass that. The point, I suppose, if that were right, would be that the words included in the service charge certificate might have to be taken to mean or to be included in the service charge certificate. But that may be stretching the meaning of clause 11 a little further than it will go.
Well, I mean, I don't want to push it on you. If you're telling us you invite us to construe relevant statement as meaning certificate, I'll note that.
My lord, that's my primary submission. But it is. I merely note that it is a little odd that it doesn't use certificate. It uses relevant statement, but that's not a defined term.
Yes, thank you.
So I was referring to the further rent payable and the sum payable by Blacks. I would note in passing, while Schedule 6 is open, of course, we've been talking about the 31st day of December in each year, but in fact, the service charge year ran from October to September. I understand this was varied by agreement at some point. And the parties operated on that basis. It's purely a point of clarification.
Sorry, so are you saying that where it says 31st day of December, in fact, the parties operated it as though that was 30th of September?
That appears to be the case. It may be the case that the 31st day of December was the date on which or after which the certificate could be served, but the service charge year ran to the 30th of September. It's perhaps unclear whether it was intended that the certificate should come immediately after the end of the service charge year.
That is absolutely contrary to paragraph 1, isn't it? Because it's the reasonable proper cost to the landlord during the calendar year ending on such 31st day of December and so forth. It may be that the parties had by convention varied all this by their conduct, but it certainly doesn't fit as a matter of construction.
My lord makes a good point, if I may say so. Yes, the year was therefore to the 30th of September.
My understanding was that the agreed position, I may be wrong, was the year was to 30th of September. Is that?
That's correct in my submission. I don't know that in front. Those were the dates that figured in the certificates.
That's the year that the landlord operated, yes, and there was no objection.
So, as a matter of
Practicality.
we would read 30th day of September in clause 1. That's how it operated.
That's how they operated, as I understand it, for all purposes, as if the year had shifted back a quarter.
That's my understanding.
Thank you.
I'm most grateful. The essence of our submission on the certification provision is that it makes the certificate, the annual certificate, conclusive with the exception of the permitted defences manifest or mathematical error or fraud. So we say that the consequence is that to the extent service charge is certified, and it all was prior to the hearing before the deputy judge, service charge cannot be challenged by the tenant unless the tenant can plead and prove manifest or mathematical error or fraud. And those are the only bases on which it can be challenged. We then go on to say that the tenant can't show any of these things and didn't try to until after judgment was handed down in the Court of Appeal. And so that is the end of the service charge dispute. Our primary submission in the Court of Appeal and below is that we were entitled to judgment on the claim or the counterclaim. But of course, the Court of Appeal accepted our case with respect to the claim, but was not certain or not decided whether any of the counterclaim could survive. And so that was remitted back.
But your case is none of this can be claimed back by way of counterclaim.
My Lord, yes. My Lord, yes.
So if it's a wrong liability, that's it, because you certified it.
Unless a manifest error can be raised, or a mathematical error or fraud, and that wasn't done. Now, if there were...
All counterclaim is quite stark in clause 3.1a, isn't it? I mean, up until then, it's plainly designed to stop withholding of rent or claiming that a cross-claim is a set-off or inequity. But to say if you've got a genuine cross-claim against your landlord because he's run over your car in the street, he's threatened your car in the street, you can't make any counterclaim. It does seem to me to be rather wider than the parties can possibly have intended. Treating the counterclaim simply as a cross-claim.
Well, my Lord, the requirement in 3.1a is to pay the yearly rent and not to exercise as against it. If
reading the clause as a whole, it doesn't, I suspect, really mean the tenant can never bring a counterclaim.
My Lord, no. And that's not my submission. What I'm submitting is that if one looks at the defence and counterclaim as pleaded, in effect, the counterclaim raises challenges to the service charge. Now, of course, if there were some independent tort or whatever it might be, then I accept that the tenant could pursue a counterclaim, but it would have to satisfy the judgment for the rent first, because that's what the no set-off provision does. And I don't want to go into unnecessary detail on this, but I did argue the point in more detail in the Court of Appeal and cited some of the authorities there. It seemed that the point wasn't really now contentious, so I elected not to burden the bundle with those authorities, but I can certainly turn up the reference in the skeleton in the Court of Appeal, if that would assist. Well, yes. If I can find it, forgive me. The point was considered in some detail in paragraphs 38 to 41 of our skeleton in the Court of Appeal. It's at the skeleton starts at 252 in the bundle, and the relevant part is 267 to 269. And the propositions we rely on, we submit are uncontentious. Contractual no set-off provisions enforceable. Court will usually give effect to it. Purpose to ensure that sums which are otherwise due remain immediately due, notwithstanding there may be other disputes. So if the court can give judgment on the claim and the counterclaim straight away, it should. And if it can give summary judgment on the claim but not the counterclaim, it should do the former and then only stay execution of that judgment in exceptional circumstances.
But all counterclaim here really means claim which impugns the landlord's right to the rent.
My Lord, yes. Or at any rate, if one looks at the wording, it is to bring a counterclaim such as to justify one in not paying the rent. That's what it amounts to. If the tenant has an independent cause of action against us, the tenant can bring the claim, but it can't hold on to the rent while it does so, and that includes service charge. So, of course, we submitted below that construing the certification provision and the no set-off provision together, the two possible results should be judgment on the claim and the counterclaim to us, or money judgment on the claim, no say of execution and directions for the counterclaim, and that the latter is what happened. Now, if I can turn perhaps briefly to our construction of the lease and of Schedule 6. There are really four moving parts here. The first moving part is that under paragraph 3 of Schedule 6, Part 1, the certificate is conclusive. The second point we say is that it is conclusive as to the sum payable by the tenant, and we say that means as to the tenant's liability to us. The third moving part is that the tenant is allowed to run the 3 permitted defences but not others. And the fourth point is that the tenant's liability to pay service charge is governed by the no set-off provision. If I could now look once again, therefore, at Schedule 6 at page 566. In summary, what we say is the certificate must be conclusive both as to the amount of the total cost and as to the sum payable by the tenant, that is, the tenant's liability. Otherwise, it's not clear what the words "the sum payable by the tenant" are actually doing, or what function they're actually serving in paragraph 3. And we also say that if my learned friend's construction is the correct one, then it is not clear at all why there is a reservation for the permitted defences, the manifest mathematical error or fraud, because on my learned friend's construction, effectively every point can be argued on the certificate by the tenant to challenge the sum claimed from it by us.
Well, I understood that the appellant's position to be it was conclusive to the extent that the paragraph 5 exercise had to be carried out, but thereafter challenges could be made.
My Lord, and the amount incurred.
Yeah.
There wouldn't be any argument about that.
Our construction is that the subject to the determination of the area, which is expressly carved out by paragraph 6, the certification is determinative of the tenant's liability, save where one of the permitted defences applies.
If the landlord knew that there was a dispute between him and the tenant about the appropriate proportion, that is, the area, the proportion which would have, in the event of dispute, to be calculated in accordance with paragraph 6, before the landlord was minded to serve the certificate, he knew about that dispute.
Oh, yeah.
Would it be said that he should defer the certificate under paragraph 3, i.e. not serve it, until that had been sorted out by the expert? because it says it's as soon as practical after the total cost and the sum payable by the tenant shall have been ascertained.
Well,
So if there's an outstanding procedure actually within the confines of the lease for the ascertainment of that part of the figure, should the landlord wait for that to be solved before issuing his certificate?
if that is a dispute the landlord knows about, if it's a dispute that has crystallised, that is to say the tenant has raised it rather than sitting on its hands and thinking that it's a dispute for the future, then I do see that must be or may well be how 3 and 6 work together, because I don't think we say that the reservation for the expert in paragraph 6 is, as it were, within the confines of the or within the constraints on dispute within paragraph 3, because separate provisions may. We're not saying one can only challenge the proportion if the experts made a manifest error. That's not what it says. We're saying the sum payable by the tenant and the amount of the total cost. So that may well be a reason to hold off serving the certificate. But in my submission, there is and I hear what my learned friend has said, but in my submission, there is a difference in quality between the kind of disputes that arise in relation to service charge, year on year, quarter on quarter, and the position in relation to the expert determination of the proportion of the building and that is demised. Ordinarily, that would be, one would expect, determined at the start of the lease. There might be circumstances where it wouldn't. But unless there are changes to the building, which mean that the area let or intended to be let changes, or unless there are changes to the demise, but those would require either a variation to the lease or a surrender and regrant, that proportion is likely to stay the same. So it only needs to be determined at the outset, and once it's determined, that's the end of the matter. And that is rather different from what is going on in paragraphs 3 and 4, where there is an ongoing process where the landlord carries out works, provides services, and so forth.
So how do you construe paragraph 3? Do you include a proviso at the end? And how do you get your qualification of conclusive on your case?
Well, the sum, okay, the sum, yes, the sum payable by the tenant. The further rent payable by the tenant in paragraph 2 is a sum equal to a fair and reasonable proportion. That's paragraph 2. Mm-hmm. The fair and reasonable proportion is not left, as it were, hanging in the air. We are told by the lease what the fair and reasonable proportion is. It's explained by paragraph 6, which is the proportion of the area. Once one has determined that, then one can put the other figures, as it were, into the equation and determine the total cost and the sum payable by the tenant. But the determination of the proportion of the net internal area is a prior stage.
Well, let's say it hasn't happened.
Well,
you're certifying the sum payable. You're saying it's conclusive, but you're recognising it won't be conclusive in relation to what is the appropriate proportion. How do you construe paragraph 3?
My lord, only if there's a challenge to the proportion of the area. No doubt in practice the landlord will say, well, the proportion is this. The demise is 40%, say.
I understand how you say it works. I'm just saying, as a matter of language in paragraph 3, how do you get that qualification into your case on conclusivity?
Well, the point in my submission is that one looks at paragraph 2, which says what the further rent payable by the tenant is. It is the fair and reasonable proportion. How do you know what the fair and reasonable proportion is? You look at paragraph 6, and it says it's the proportion of the demise presents to the rest of the building that's let or intended to be let.
Right, but you will be saying in your certificate, conclusively what that is, but you're recognising that that is open to challenge by expert determination.
So are you reading in subject to paragraph 6? It is conclusive subject to paragraph 6, or I think that's what
Yes.
Lord Hanlon's question is. What words are you wanting to read into paragraph 3?
Well, paragraph 3 certifies the sum payable by the tenant. Paragraph 2 tells us that the sum or the further rent payable by the tenant is determined in a way which is set out in paragraph 6. So one tracks from
But paragraph 3 says, it's only when that sum has been ascertained that the landlord should serve the certificate. I mean, I just wonder whether a landlord under this lease should first ask his tenant, are we agreed about this area proportion? If not, let's get it determined before he ever comes to try and finalise a service charge year by serving one of these certificates.
My lord, that may be the right answer on that point. I'm not aware that the challenge has been presented by the tenant in this case to the proportion. That's not, as I understand it, the way the tenant puts the point. But I can see that if the tenant were to turn around and say, look, it's not 40%, it's 30%, then that, on the basis of our construction of 2, 3 and 6, is a prior issue that has to be resolved before one gets to the sum payable by the tenant. But that, in my submission, follows from the way 2, 6 and 3 fit together. In my submission, it doesn't require further words to get there.
No. Would that be a convenient point at which to adjourn the short adjournment?
My lord, I'm most grateful that would be a good.
Thank you.